Thank you so much. I'm Scott Keeley, and I'm part of the patent firm Keeley D'Angelo. We're a small firm with very low overhead, and we help inventors, small businesses, independent entrepreneurs, and small teams with their patents and intellectual property. I'm actually a patent agent. A patent agent does everything a patent attorney does. I just don't argue in court. So I do everything between the inventor and the patent office in terms of getting your patent granted, drafting, filing, prosecuting. And then when there's an infringement issue, we have a litigating patent attorney that we bring in for that. And I come about the patent business a little differently. I was in product design and development for 25 years or so. Before one of my clients needed help with patents, I took that on and eventually led to taking the patent bar. So unlike a patent attorney, I've been in product development a little more hands-on for a little longer. So anyway, here goes a little bit about my experience with licensing. I've got a lot of stories, success stories, a couple of failure stories in there, things to avoid, and the like. So here goes. I'll share the screen. And I have too many things going here. I have a rendering going on in the back. So let's see. Let's pull this one up. Can I share the whole desktop?
Yeah, it was locked. I just unlocked it. So you should be able to have the share screen feature.
Okay. Here we go. Does everybody see that?
Yes.
Slide.
We do. It's in presenter mode though, so we can also see like the next slide in your notes.
Oh, geez. Sorry for that.
No, it's okay.
Let's see. How shall I?
There you go.
It's good now?
Yeah.
Okay.
It is showing the next slide coming up. Do you want to do that?
Didn't want to. Let's see. How do I?
Yeah, look around there and see what it says.
Current slide.
There we go. How's that?
Perfect.
Great. So a little bit about licensing intellectual property. I am with Keeley D'Angelo LLP at KeeleyD'Angelo.com. So the beginning of a licensing agreement and how licensing works, it's a little like a marriage. Both people give something up and both people hope to gain more than what they gave up. I hear oftentimes from inventors, well, you know, they want an exclusive licensing deal. What if I find something better? And one person described it to me as, he said, you know, that's kind of like saying, well, I really want to marry her, but I want to fool around. And you're on the altar at the moment. That's not the kind of thing to talk about. So licensing deals tend to be exclusive for a good reason. The licensee who's planning to take on your invention, it's likely to cost something in development. And, you know, for a simple product like a snow shovel, you're looking at injection molding, tooling, manufacturing, packaging. You're looking at about $100,000 over the course of a year to develop your product. And they're hoping to earn that back. And one way to do that is to be the only game in town. So that's why we tend to see exclusive deals. You know, and other times inventors say, well, what if it doesn't sell? Typically, you know, an honest licensee, if you've got something that's selling zero product, they'll let you take it away from them. So as one licensee said to me, if your product's a dog, I'll tell you first before you ask to take it away. I'll tell you that we're just not selling any. It's time for you to take it somewhere else. So that's a little bit about the overview of licensing and why you tend to see exclusive licensing. So where to begin? Protecting your invention is very important. At least a provisional patent is useful. Some people will ask about NDA agreements. If someone asks you to sign an NDA, that's a good sign. It means they want to make you comfortable. An NDA is an agreement between the inventor and the licensee saying, where the licensee is saying, we're looking at your invention for the potential of evaluating it to do business with you, not for the potential of taking it away and selling it without you. NDA, by the way, stands for non-disclosure agreement. And that's what the agreement is about. It's the other presenter here in the room is my dog, who is very interested in the mailman who always brings cookies. You'll hear that in the background now. She'll get tired and eventually. So the non-disclosure agreement, if a company doesn't want to sign a non-disclosure agreement, that's not a sign that they're looking to be devious or looking to screw somebody. This will just take a second. They're dropping off a package. Almost done.
It's where dogs know when it's UPS or before they see them.
She often thinks she's helping by, she usually gets a squeaky toy because if she hears the noise, hears me talking, she comes to help by squeaking. I think we're all quiet now. So when a company doesn't want to sign an NDA, it's not a sign that they're looking to screw the inventor. It's more of a sign that they've been taken advantage of by inventors. I had a case where my son and I had met a toy broker. The toy broker presents toys to the major toy manufacturers. It just happens to be the way toys are done. They don't usually talk to independent inventors. They like to go through brokers. And the toy broker had a specific inroad to Disney. My son and I came up with an interesting toy. It was Mickey's wand. This was the time of Harry Potter had just come out. And we said, hey, what if you had a swish and a flick and it made your sister's hat light up, or your whoever was wearing the hat, it'd be Mickey's wand and the wizard's hat, They loved it. They presented it to Disney. It went straight to the desk of the president of the toy division. And he pulled out a sketch from 2 years prior of exactly that idea. And this is particularly why NDAs are often not signed. The company may have already had that idea. They may have been working on it for 6 months. And if they sign an NDA before seeing your product that they promise not to produce it, now things are kind of sticky. And in that case, my presenting it to them may have made them think, hey, let's pull up that idea from 2 years ago and do something with it. They still had it first. They have every right to do that. But if I saw that idea come out in 6 months after they told me no, I'd be a little upset, rightfully so. They didn't decide to go ahead with it. They said, yeah, we evaluated, it didn't make sense. And so don't worry about the NDA. If they sign it, if they want to sign one, that's great. If not, the main thing you want to look at is protecting the invention so that you're comfortable. We usually start and recommend a provisional patent application. A provisional patent application gives you patent pending status from the moment it's filed, and it's good for 1 year. Before that year is out, you'll want to file the non-provisional application to keep patent pending status going until your patent is granted. But patent pending status is, puts the world on notice that you intend to go ahead until this is a granted patent. The other benefit of the provisional patent is that an NDA is really an agreement between me and one other guy. It's not an agreement between me and that guy's brother-in-law who hears about it at a cocktail party and goes off and does something with it. I used to think that was a little far-fetched until it happened to one of my clients. The provisional patent says patent pending, and that's an agreement between me with the patent office behind me and the rest of the world, because during that year, you still have the option of even filing internationally. So provisional patents can run the gamut. The patent office has a pro bono system that you can apply for, and if eligible, they'll put you in touch with someone that'll do it for free. You still have to pay the filing fee, but you can get the patent drafted for free. Some people file their own, and some people go to a patent practitioner like myself. So there's a range there. We, of course, recommend the patent practitioner unless you're eligible for pro bono services. But filing it on yourself, filing it pro se, as they say, filing on your own is better than nothing. Another place to begin, the second most important step, is typically the greatest success comes from a team. The entrepreneur, the producer, the administrator, and toward the end, or as the company grows, the integrator. And to illustrate these, you have a group of people in a meeting, sitting in a conference room. The entrepreneur looks out the window and says, that parking lot is just not designed right. We could rearrange that and give people better access to come and go, and even park more cars if we did this differently. The producer, often an engineer, looks at the window and says, that's not even thermal paned. Why don't we have energy efficient windows here? The administrator says, you're right, that should be thermal paned. Why don't we do a break-even analysis between the replacement of that window and the amount of energy we're losing and find out how many months of energy savings it's going to take to replace that window. The integrator says, are any of these people talking to each other? And why not? So with that kind of a team, you have a much greater likelihood of success. Typically, the producer is an engineer, the administrator is somebody with a business head, and that integrator comes in when you're looking into having a human resources person commonly. I've got some pictures here of some. These are all stories of why you don't want to do it the way they did. Anybody know what these pictures are? Go ahead and unmute your mic if you know any of them. Let's see. I'll take you through them. If I'm missing something, I don't have the chat up. I've got a full screen. Anyway, top center, that little red car is, drawing a blank on the name. I'll think of the name, the name will come to me. This car was Elio Motors. This car was developed, about 6 or 8 years ago. It's a 3-wheeled, gas-powered car, 2-seater. The passenger sits behind the driver. It's hugely efficient, something like 80 miles to the gallon, and it costs $6,000. You could pre-buy it for a time. I think they've gone Chapter 11. I don't think they came back out of it. I knew somebody that had invested, and I said, how's it going with that Elio Motors investment? And he said, well, they've got the engine down. They're going state by state because they're a 3-wheeled car, and most states call a 3-wheeled vehicle a motorcycle. So they're working on changing the laws in every state. I'd have put a 4th wheel on it and come up with the 3-wheel version in version 2. One of the reasons this sort of thing happened at Elio Motors is that the entrepreneur was also the CEO. The big difference between an entrepreneur and a business person is that the entrepreneur is always looking for something better. If everything were good enough for the entrepreneur, why bother? Where the true inventor looks at even their coffee mug and says, hey, wait a minute, I could do this better. So he was right. The 3-wheeled vehicle is more efficient, has less friction, less drag, better gas mileage. But to come out with a 4-wheel version, as a business person would say, let's get it good enough so we can sell it, and we'll make more improvements later. Clipper Wind, another entrepreneur as CEO, and I was talking with an engineer of the former Clipper Wind Company who was talking about various engineering aspects. And he said, you know, they were problems in the engineering. We knew they could be addressed. We knew how to address them, but we needed time and money. And the CEO said, no, we're going with what we've got. And the company failed. Typical, you know, as he was telling me the troubles, I said, by any chance, was the entrepreneur also the CEO? And he said, he was. How did you know? And it was pretty clear. And the 3 pictures at the bottom right, a brilliant man, fabulous inventor, Buckminster Fuller, Bucky Fuller, known by his fans. And again, he insisted on negotiating his own contracts. He invented 3 different home styles, all of which were designed so that a person could pay off their home within 3 years. And he even came up with his own aerodynamic car, rivals minivans today for efficiency and function. And none of his businesses ever succeeded. He would get down to the point of signing, take his drawings, take his papers, and go home. Just his nature. So forming that team is most likely going to bring you to better success in licensing something. Couple of stories.
This is Mike. I got a message from Dax, and you may have this later on in the PowerPoint, but Dax was wondering if there's some kind of general, easy to remember guidelines to knowing what is and what is not patentable.
Oh, going back to patents. What is and what is not patentable? That's a good one. You know, they used to call it a flash of genius. Now they have various guidelines of the Patent Office. The main things you come up against in patentability are the Patent Office Law 102 and Patent Office Law 103. 102 says somebody else invented it first. You can overcome this by doing a patent search, even by going to Google Patents. It's a great start. Your patent practitioner will usually do a search before going through the trouble of drafting your patent. So if somebody invented it first, filed something before you, then it's not patentable. The other hurdle at the Patent Office, the other big hurdle, is known as 103, which is obviousness. So the invention has to be something that someone with ordinary skill wouldn't have thought of. That they wouldn't say that somebody of ordinary skill would find that obvious. You know, you stuck 2 things together and the like. And we can jump back into that more at the question and answer at the end. Here's a couple things. Flash of Genius was a movie about the inventor of the intermittent windshield wiper. We're talking now, about licensing, dealing with large corporations. One of the things I often recommend to inventors and entrepreneurial teams is to start with a smaller company first. If you can find a local manufacturer or one of the little guys that's trying to get a leg up, maybe trying to get just a little more shelf space in the store against the big guys, you're much more likely to be able to deal directly with the head of the company. You know, the fact that they're smaller, you're more likely to be able to call and talk to them. A really big company can be really daunting. The guy that invented the intermittent windshield wiper in Flash of Genius, he made some classic mistakes, and he wanted to be the head of his own company, and he made all the classics in terms of mistakes. But he went straight to General Motors with the intermittent windshield wiper. And he had never licensed anything before, never manufactured anything before. They ended up taking it from him and doing the wrong thing. He won in court, but and he made some changes in the patent laws that benefited the little guy, but it didn't go well for him. It was a long, arduous fight. Let's see, Kingsford Charcoal, an interesting story of an inventor I met years ago had come up with a charcoal briquette that looked sort of like a coconut macaroon. it went out to papery thin edges. Turns out if you light with charcoal as thin as paper, it lights like paper. So this was a briquette that could be lit consistently without using lighter fluid. He took it straight to Kingsford, and Kingsford said, "That's a great invention. We wish you all the best. But if we make it, nobody will buy our Kingsford lighter fluid." Interesting thing about Kingsford, he found out in that meeting with them, he did get all the way up to a meeting with the company at the headquarters. Kingsford is a division of Ford. It spun out of Ford when Ford was making a lot of pallets, a lot of oak wood pallets for shipping their parts. And he said there's so much sawdust from making oak wood pallets that this sawdust is what they end up using in the briquettes. And he said he didn't know, he couldn't remember if it was the Kingsford Charcoal Company paying a penny a ton for the sawdust or the Ford Motor Company paying a penny a ton to have the sawdust hauled away. So it's basically free raw material, and they make a lot more of their sales on the lighter fluid than they do, or a lot more money, a lot more revenue from the sale of lighter fluid than they do from the sale of charcoal. So he was, at that time, looking for a smaller charcoal company that would be more interested in getting a leg up on the big guys. And another company there, they make a lot of shaving products. I don't use a lot of those, but I knew somebody that worked at the company. They had an interesting policy. They said that if an inventor came to them with an idea that they liked and they wanted to produce, and that inventor had some kind of intellectual property protection, even if they had handwritten their patent and filed it on their own, they would work out a licensing agreement. But inventors that came to their door, all enthusiastic about their idea, and showed them an idea with no protection, they would take it and make it and not work out a licensing deal with the inventor. Sounds pretty cruel, sounds evil, but technically they're not breaking the law any more than one would if you decide to store your $20 bills on the sidewalk and I pick them up. You can get mad at me, but I haven't broken the law. And that was their company policy. So another good reason to work with the little guys on up and then work up to the big guys. Should I sign a contract? So I have a great success story followed by this short, not such a great success story. A client came to me one time years ago before I was working in patents. That was around 2005. And he had a very interesting product. And I was working with a catalog representative at the time. And the catalog representative was always looking for something new. Saw this product, he loved it. He said, you know, we're going to a trade show next week. This would fit right in with what we're showing. Why don't you tell him to send us a sample? Here's our contract. The contract was about 1 page long. It was not very complicated. It basically said, we sell product to make money. When we sell your product, you'll make money. Here's how much. Sign here. Not too hard to understand. The inventor got a little nervous, went to an attorney who came back with an 11-page contract that had a lot of fine print. The catalog representative said, I'm sorry, my attorney wouldn't let me sign this. He basically, if something goes wrong and somebody hurts themselves with his product, you know, he wants to put me out of business. I can't even start. So if he can't sign mine, we won't do it. This is what his page looks like now. 404, page not found. He never did sell another one of them. It was very sad. Sometimes it's good to trust somebody at some point and sign a contract when it's in front of you. And one person who did that was one of our clients, Howie Rosenshine, comes to us from Next Fab in Philadelphia. And if you Google snow shovel right now, chances are you'll see this image here in the upper right. It's the best-selling snow shovel in the US and Canada. It has this spring steel second handle. And Howie had presented his idea through a licensing agent. The licensing agent presented it to Snow Joe, a company that sells, it's a Canadian company, sells in US and Canada. They offered a royalty agreement, and I think it was about an 8% royalty. And the agent said, "Oh, I got this all planned out. We're going to get them. We're going to play hardball. We're not going to respond to them for 2 weeks." And Howie said, "No, that's okay. I think I'll sign the agreement. It's a fair agreement." And he was right, and he's doing very well with this now. It just came out this year. I know we didn't have a heck of a lot of snow, certainly not in Philly. But nonetheless, it came out in Walmart and Home Depot. It was at the end cap on numerous aisles. It's been a great year for Howie. It's been a great number of years. And he's still presenting new products to Snow Joe, hoping they'll take another one. And it's a matter of time. Howie is an interesting guy. He has a way of realizing that he really needs to put everything aside and get out of his workshop if he's going to work on a contract. And he sets aside a day to be the CEO and another day to be the inventor, and doesn't let those people know each other. They're both called Howie. But a great success story from one of our clients. So what to expect in a licensing deal? You can get, the expectations can go up as the labor into the product goes up. So if you have just an idea that you've sketched on a piece of paper, you can expect a 1% royalty. If you have a functioning prototype that's ready to put down on a table and show somebody how it works, that's up a next level. If you have IP protection, that goes up another level, and depending on the level of the IP protection. Some companies, I know Colgate, for example, won't even talk to you unless you have a granted patent. They don't want to know about patent pending. If you've got something granted, they'll talk to you about licensing it. If you've already started the first run manufacturing and you've sold some of them, our friend Howie had sold 2,000 of his shovels at the time he was making just the second handle that you would adapt to any snow shovel. And he had sold 2,000 of them. He was quite proud of that, and he told the licensing agent, and the agent laughed. So 2,000 is not a lot, but nonetheless, it is a major milestone. It means you know the product can be manufactured, you know how much it costs, and you have someone you could go to if suddenly they needed 10,000 of these things. So it goes up as volume goes up. Be ready to consider an offer. An important thing is don't expect to make new rules in an existing field. I've heard things from inventors who say, "Oh, I looked into licensing, but I would never consider that. I hear you only get up to 9% royalty. And you know, who's making the other 91%? That's what I want to know." Well, first of all, if you look at the breakdown here, half of that cost is in the materials and tooling. Neither of you, neither the licensee nor the inventor, get any of that. That's just to make the product. And you've got at least 10% in shipping, and then warehousing, sales, and customer service. Somebody has to answer the phone when they can't figure out which end of the screwdriver to turn the screw with. And you probably don't want to do that. So somebody has to do it. And by the time you break it all down, you know, many companies are working on between 12 and 20% profit margin. So if they're giving you 9% and they're earning 11% to do all the work, it's a pretty fair deal when you look at it that way. And in terms of making new rules, I've heard people say, "Oh, well, we're not taking no 9%. We're going to get 50% at least." I never heard one come back to me and say, "Hey, we got our 50%. You know, after somebody would, that would leave nothing after buying the materials. You get 50%, we got the materials. Well, they haven't been assembled or packaged or sold or shipped, so not a product. You can price yourself out of viability in that way. So finding a licensee. There are trade shows. You can often go to a trade show as just an attendee. You don't have to set up a booth. I often recommend that, that first-time inventors attend just to walk the floor. You can talk to people, find manufacturers who might be interested in your product. You know, tell them it's patent pending, show them a one-page sell sheet. There's a lot you can do just walking the floor. Trade show, a booth, the smallest booth might cost $1,500. It's a big investment to stand there and hope that somebody's going to come by. Walking the floor can be much more affordable, and you can learn just as much. There's a show right in Philadelphia that happens every year, a manufacturer's show. There's also the National Hardware Show that happens each year. I can send you links to those if you drop me your email in the comments box. And there's also the Thomas Register. The Thomas Register can be found at your local library or online. And it's a list of manufacturers by state or by location. So you can look for a manufacturer who might make products like your invention. And you know, if they don't actually sell to retail, they might be able to tell you who they work with. Great way to start. A lot of people go with the Kickstarter, Indiegogo, the crowdfunding options. I don't personally have a lot of experience in that. A number of my clients have. One client explained it best, that he said it's a lot like climbing Everest. It sounds like a great idea, sounds like a great adventure. In the end, when you're done, it's always a great story. But when you're in the middle of it, you wonder why you ever started doing this to begin with. And a lot of people don't come out well. There are more analogies. It seems as you think about climbing Everest or talking to people that have, it seems closer and closer to a direct analogy to crowdsourcing your invention. Other places to get help with that. I know NextFab in Philadelphia has a connection with some agents and people that have helped with that. I do have a client that's working currently with QVC, and QVC and As Seen on TV can be a great way to get a start. It's sort of where catalogs used to be. Not a lot of people buy from paper catalogs so much anymore, but the rule with things like QVC and As Seen on TV is that if you go straight to retail, you just lose whatever you could have sold through QVC. So if you were going to sell 10,000 units a year through QVC and another 5,000 through As Seen on TV, and then after 2 years you go retail, now you've sold 20, 40,000 units or so. You get the profit from those 40,000 units you sold, and then you go on to retail. If you go on to retail, you can't go back and sell it on TV. People would rather just buy it retail than get it off the television. They are like Indiegogo and Kickstarter for the new and untested, the beta tested type products. A couple of resources: the USPTO Inventor and Entrepreneur page. I'd be happy to send you that link. Let me see if I can. Oh. See if I'm still shared there. Do I need to share that separately, or do you see that?
You have to share it, so okay, go ahead.
Okay. Let me do that. So the USPTO has a nice resource page. I don't know if you can see that link at the top. One of the best sections of it is the protect your invention and avoid scams. There's a list of links here where you can look up if somebody's been calling you about your invention. They'll do that if you get a granted patent. You can look them up here and see if they have been reported as a scam. There's a lot out there. One of the famous ones, I've had clients call and say, somebody called and said they would find a licensee for my invention. I just have to send them $2,500. Don't do it. They don't have a lot of incentive after taking your money to actually make those calls and see it through. And there's also the other resources here. Exploring the patent application process under patents. All of these are great resources, trademarks, etc. And let's just go back to the presentation. A lot of the information we've presented here, we learned from a guy named Jack Lander, the Inventor Mentor, inventormentor.com. And also, I not being a patent attorney, not being an attorney, I can't specifically draft a contract for you, but I have links to sample contracts if you're interested in seeing an example licensing contract. And there we go. Does anybody have any questions?
Hi, this is Allie. I do have a quick question. So in the beginning, you were talking about the provisional patents and whatnot.
Mm-hmm.
So when I was like in college, I started exploring something, and they had sent me down the road of doing like a patent search first. What is the order? And it might be in one of your resources, but while we're all on the line, like what is the order of like a whole patent search versus a provisional?
So a patent search, if you're doing it on your own, of course, it costs nothing. It always costs less than having a provisional patent drafted. But you know, knowing that there's nothing else out there is really the best first step.
So doing that first before you file for a provisional?
Oh, absolutely.
Okay.
Yeah.
And is there a resource, maybe in something that you just shared with us that, because I know for most of us, it's probably important to know what are we getting into financially. And I know obviously there are certain things you could do on your own, but just sort of like a range of prices just for planning purposes.
Yeah, the national average for a provisional patent is between $2,000 and $3,000. The average for a non-provisional is between 4 and 7
Per
They
year?
vary widely depending on complexity. So
the non-provisional is the one that you repeat every year, right? Until
no, the provisional patent is what you file and it's good for 1 year.
right.
And then within 1 year, you file the non-provisional. That's the one that takes 12 to 18 months to come up for examination. And once it's up for examination, it takes another 6 months or so, 6 to 12 months to get granted. And once granted, is good for 20 years.
Gotcha. Okay.
Yeah. Some people do file a provisional patent repeatedly every year. That's okay if the invention has only lived inside your laboratory and has never been seen by anybody outside of your own inventor's laboratory. It's not, I have met people that thought they found a loophole in the patent process and they just refile their provisional. They say, hey, it's only $70 a year and I can do it forever. You can't actually. After you've publicly disclosed your invention for more than 1 year, you're barred from ever getting a patent. That's why it's okay if it's only lived within your laboratory and you think, well, we didn't do anything with it. We still think it's good. Let's re-up the provisional. You give up that original filing date and you accept the new date. So you lose there's a chance that somebody else may have come up with the idea in the meantime, each time you do that.
Thank you.
Sure.
How does it come? I have a question, and I think it'd be beneficial for a lot of people. When it comes to, of course, you practice both nationally and internationally. When it comes to licensing internationally, could you share some thoughts on processes, best practices for people to understand?
Yeah, so I guess it depends on whether it's a U.S. company that's selling internationally or a whole-on company in a different country. So when you file that provisional patent, you have that 1 year to make two decisions. One is whether you're going to go on with the non-provisional or not. And the second decision is to decide if you're going to file internationally. An international application is not cheap, even if you were eligible for the pro bono system through the U.S. Patent Office. You still have to pay the filing fees. For a micro entity, the lowest cost possible filing fee for an international application is around $2,000. And that just gives you that just holds your place in line so that 18 months later, you can start paying fees to each country you decide to do business in. So as a ballpark, think of about $10,000 per country. And when they come in at 8 or 6, you can be happy about it. But it's a big investment to file a patent internationally. For my own work, I have covered US and Canada for 2 inventions that I have kind of out there working on licensing deals now. And, unless I had revenue already coming in on the invention, it doesn't make sense for me to go internationally. Some people it might, depending on the product. And if you have funding and investors and that sort of thing.
Wonderful. Is there any other questions?
Patentable, something defined. So how is something defined in the public domain? So there's 2 ways that something can end up in the public domain. If the inventor doesn't seek a patent, or if the patent is ultimately rejected by the patent office and they decide to give up fighting, or if a patent is older than 20 years. So a utility patent, for example, is good for 20 years. After that, it's automatically public domain. And that's pretty complete. Somebody called me with they were interested in publishing a book of interesting design patent drawings. His idea was that some of these patent draftsmen were really good artists and completely unsung. He was a little concerned about companies coming after him, like Disney, for example, for their expired patent for Mickey Mouse. It's a good question. The patent office answered it pretty clearly. They said, it's an expired patent. It is public domain. And they were willing to stand behind him on that, even if Disney came after him for publishing the patent drawings of Mickey Mouse.
That's wonderful. So I'm going to send in the chat a couple things. Right now, I'm going to let you know 3 things, and it just popped it right now. I sent you a link for the agenda for the rest of the sessions. Mm-hmm. Also, if you have time, don't forget to join the virtual Thursday Gathering networking room and connect with other people here. I also included Scott's contact information. As he mentioned in the beginning, he basically, his firm researches, writes, file, and prosecutes patent application for both the U.S. as well as international. He's got an office both in Philadelphia and Rhode Island. For someone being, I'm in wealth management, and I deal with a lot of entrepreneurs and businesses all the time. People like Scott is a godsend. It's extremely important to have someone like him on your phone, because if you need assistance, he is well polished in the process, and he could actually make life a little easier. So don't hesitate to reach out to him at any point, and we appreciate his ongoing educational journey with us to help us from step 1 to step Z along the way.
Thanks.
So, thank you very much, Scott. Everyone, like I said, this contact information is there if you need to reach them. Don't hesitate to reach them. I would if I was you, because it's extremely important.